I did say I could smell a strong odor of alcoholic beverage, but there was no signs of alcohol from the individual. Based off him not wanting to do field sobriety, that I believe he would be under the influence.
Then after he did and told you you would have been sued, at that point you did arrest him?
Yes, sir, because I believe he was under the influence. If he shows up, he's a witness, so he can't represent you anyway.
Are you trained to tell people they can't call the lawyer?
No, sir. But
under what authority do you have to tell somebody if they try to call a lawyer? You can't call him, he can't represent you.
Nate Stevens spent the night in jail insisting he had done nothing wrong. But months later, every decision made on that roadside would be tested under oath, and the officer's own body camera was about to become the most powerful witness in the courtroom.
We call the case of Nathaniel Stevens, 25T 1902, on for refusal hearing. Is the Commonwealth ready?
Yes, Your Honor. Is
the defendant ready?
Yes, sir.
Call your first witness.
Commonwealth calls Officer Michael Bell.
Would you raise your right hand, please? You swear affirm testimony you're about to give is truth, whole truth, and nothing but the truth, so help you God?
yes, Your Honor.
Thank you.
Say your name for the record, please.
It's Officer Michael Bell,
How are you employed?
the Grayson, Kentucky Police Department.
Were you employed at that capacity on October 6th of last year, 2025?
Yes, sir. Yes, sir.
And did you have the occasion to come into contact with Nathaniel Stevens?
Yes, sir.
And was he placed under arrest for allegedly driving under the influence?
Yes, sir.
In our last video, Nate was arrested for DUI after reporting a neighborhood crash, blowing 0.000 on a breath test, and completing every field sobriety exercise. Now, the case had reached the courtroom, where one question remained. Did officers actually have probable cause to arrest him?
The call was that Mr. Stevens was the victim of the accident.
The call came in that there was a two-vehicle non-injury accident. While myself and the sergeant was responding, we was notified that one of the vehicles had left the scene.
Okay, and did you later learn that it was a 17-year-old kid who backed out of his driveway and hit Nathan?
Yes, sir.
And that he and Nathan exchanged information and there was no issue till his father learned about the accident later in one of the police reports. Is that accurate?
Officer Michael Bell took the witness stand and swore to tell the truth. Under cross-examination, every decision made during that traffic stop would be measured against the body cam footage and the law.
Plus, I'm going to object because we're having a refusal hearing. I'm not sure how this would...
How's this relevant to the refusal
Well,
hearing?
it is relevant for a couple of reasons. We do have knowledge because his body cam was on the entire time except for when he covered it at Whistler. And second, during the entire encounter, there was no indication he was under the influence until a couple of things happened. So I'll keep it very brief, just a little bit of foundation.
Yeah, if you think, I'll let you have a little leeway there.
Thank you.
Defense attorney Derek Willis began with the basics. Dispatch records showed officers responded to a non-injury traffic accident, not a suspected DUI. Nate wasn't the driver who caused the crash, he was the victim. So what legally turned a routine accident into a DUI investigation?
You claim that you smelled alcohol, correct?
I don't believe so. Let me double check before I testify to that.
The defense then challenged Bell's report, where he claimed to smell alcohol on Nate. But the body cam showed Nate voluntarily taking a breath test and blowing 0.000. If alcohol had been ruled out immediately, what evidence justified continuing the DUI investigation?
I did say I could smell a strong odor of alcoholic beverage, but there was no signs of alcohol from the individual.
So when you told him that you smelled alcohol, he looked at you and went, did he not?
Not that I can recall. I mean, I don't want to say yes or no.
Bell admitted under oath that the breath test detected no alcohol. That single admission changed the case. Once alcohol was eliminated, the court had to decide whether any objective evidence remained to support probable cause for a DUI arrest.
And at that point, you got pretty close to him and said, if you make another aggressive movement toward me, I'm going to put you under arrest.
I did say that, yes, sir.
Was it an aggressive movement to breathe so that you could actually...
Judge, I I don't understand what this line of questioning is for refusal. I still haven't caught on to, I've given him a little leeway to try to get to.
I'm going to let him ask the question. Go ahead.
Attention turned to drug impairment, with Bell suggesting Nate might be under a narcotic. However, the defense pointed out that no drugs, paraphernalia, or evidence linked Nate to any substance. According to the Fourth Amendment, probable cause requires objective facts, not speculation.
So did his hesitation all along appear to be lack of explanation, lack of understanding, rather than lack of cooperation?
It was a passive, he was very questionable about it, but I explained it the same as I would do any other traffic stop.
But his behavior and the fact that there was nothing in the PBT was consistent with no alcohol consumption. Would you agree?
Yes, sir.
After the PBT, he tried to call me, didn't he?
I don't know who he tried to call you.
Well, on the video, you say if you call him, he'll be a witness and he can't represent you.
I said if he comes down here, he'll be a witness.
What's your name?
Bell, it's right here.
Okay. What's your name?
Sergeant Hall.
Okay.
If he shows up, he's a witness, so he can't represent you anyway.
So presumably he's trying to call me, right?
The hearing revisited one of the stop's most controversial moments. Nate repeatedly tried to contact his attorney, but Bell told him that if his lawyer came to the scene, he could become a witness and no longer represent him. Under oath, Bell admitted making that statement, raising questions about Nate's access to legal counsel.
Are you trained to tell people they can't call their lawyer?
No, sir. But
Under what authority do you have to tell somebody if they try to call a lawyer, you can't call him, he can't represent you?
on the point of a traffic stop, you're detained until that. You're afforded an opportunity if we go for any kind of chemical testing.
So back with the testing, again, he said he didn't want to take a test without his lawyer present.
Mm-hmm.
And you previously told him if his lawyer's present, he can't represent him.
For the observation testing, but he's afforded an opportunity to communicate with an attorney via phone.
The defense argued Nate wasn't refusing to cooperate. He was trying to understand his rights. The body cam showed him taking the breath test, completing the field sobriety tests, and answering questions. Does asking for clarification turn cooperation into obstruction? The Constitution says rights don't disappear during a traffic stop.
Everything was recorded on the body cam, wasn't it?
Yes, sir.
And there was a point in time after he took the PBT and after he took his field sobriety test that you said, I'm going to issue some citations. I'm going to go over and talk to the other attorney. Is that correct?
Yes, sir.
And at that time, he was not under arrest.
He was still detained, but he was not under arrest at that time.
And you indicated he wasn't under arrest, that you were just going to give him a citation.
He was going to get some citations, but I never told him if he was or was not going to be placed under arrest.
And did he ask you what's the citation for? You told him you'll find out when I get it.
As in, I'll explain it like I do every traffic stop, each charge that's on the citation.
And then afterwards, you went and spoke to the victim, or not the victim, the perpetrator actually, and his father, who were standing off to the side, correct?
Then came the turning point. After telling Nate he would likely receive citations and leave, Bell stepped aside with his supervisor and moved his body camera away from the conversation. Minutes later, the decision changed. Nate was suddenly under arrest for DUI. But what new evidence justified that reversal?
And then afterwards, you went and spoke to the victim, or not the victim, the perpetrator actually, and his father, who were standing off to the side, correct?
Yes, sir.
And you told him, I'm going to hand out a citation. You can come to the police department in 2 days to get a report.
Yes, sir.
And you didn't tell him he was under arrest.
I did not tell the other party that he was under arrest, no.
You came back and you told Mr. Stevens, if you hadn't have done the standardized field sobriety test, you would have been under arrest.
I did say that, yes.
And when you said that, he said, well, you would have been sued. Is that correct?
To the best I can recall, he did.
And your response was, no, I have qualified immunity. I wouldn't be sued.
I don't recall that.
Okay, it's in the video. We'll watch it.
Bell claimed Nate appeared nervous, paced around, and wasn't cooperative, but the defense pointed to the body cam, which showed Nate calmly standing, following instructions, and completing every requested test. If the video contradicted the testimony, which evidence carried more weight?
I will set aside the refusal.
By the end of the case, the DUI charge had been dismissed, and the alleged blood test refusal had been set aside. What began as a roadside arrest ended with a courtroom exposing serious questions about probable cause, constitutional rights, and police accountability. Sometimes the most important witness isn't a person, it's the body camera recording every moment.